I am going to put the link to the sign-in form in the chat again. It does not appear to be visible to everybody, so I'm going to drop that link back into the chat.
Oh, perfect. Okay, thank you. Yeah, and I know Janine's already said it a few times, but please, please, please do just take a minute to fill that out, because the more we're able to show attendance to our funders and regulators, the more it just helps us be able to host cool things like this, where we get guest speakers to really give out free information to the community. So as today, you know that we're here to talk about tenant rights and responsibilities, handling emergency situations. So this is being offered today by the Department of Housing and Financial Services at Great Lakes Credit Union, but we are very, very happy today to have Prairie State Legal really doing the bulk of this presentation. And we have Katie Pinter with us today, and we're just going to be doing introductions here shortly. Work. So my name is John. I am the housing counselor at the GLCU Uptown Chicago branch. In March, I'll have been with the Housing Counseling Agency for about 5 years, and have done pretty much the gambit as far as housing and financial needs. So really excited today to be here.
Well, hi, my name is, whoopsie. Oh, there I am. I'm sorry. I thought I was muted. I started and I thought I was muted and I stopped. Let me start again. Hi, my name is Janine Folan, and I am co-hosting with John. And I started with Great Lakes Credit Union in late 2020, but I have been in this business for 11 years. My previous agency was in Wisconsin, and I assisted people with debt management plans, bankruptcy. I taught first-time home buying and tenants' rights and responsibilities classes, among other things. My office is in Country Club Hills, but all of our counselors do in-person, phone, or virtual appointments. And we can actually see people who reside in the states of Illinois or Wisconsin, or who are moving to those two states. I really enjoy helping people resolve whatever difficulties they are facing, or simply start the next chapter of their financial life. And I'm going to turn it over to our very special guest speaker, Katie Pinter.
Good morning. My name is Katie Pinter. I'm a supervising attorney with the Waukegan office of Prairie State Legal Services. I have been there for over 15 years, and my focus is on housing law.
Thank you so much, Katie, and we're very excited to have you here today. Okay, just going to go through a few quick things before we get started. So Great Lakes Credit Union's Department of Housing and Financial Services propels financial health by providing exceptional financial education and counseling in the areas of credit and financial management, home ownership education, and foreclosure intervention. So there's just a quick mission statement for the department, just to kind of let you all know in a nutshell what we're kind of trying to help out with on a daily basis for free. So you may be asking, okay, what is a HUD Housing Counseling Agency at Great Lakes Credit Union helping out with? Well, there are a few different categories. First, today would be an example of that. That's financial education. So every month or so, we usually try and hold a webinar or sometimes an in-person event where we can talk about a certain topic as it relates to law or financial literacy. Usually if it's pertaining to law, that's where we get a speaker with that kind of background to kind of get into it. So sometimes that's been everything from really understanding foreclosure in the CARES Act to pre-purchase and how to be getting ready to buy a home, to even just basic things as far as financial products, credit, things like that in a workshop setting. As far as like the actual counseling agency goes, if you're coming to us, we can do one-on-one counseling, and that can be over Teams, over a phone call, in person. You just have to basically fill out and get the appropriate documents for us to start working with you. And then we're completely free on a continuous basis as far as helping out with different things. So that can be pertaining to credit counseling. If you want us to be doing a free soft pull on your report where it's not going to be impacting scores or showing up in history, we can talk to you about things that are on your report that you may need help with, even understanding how the score works and just kind of getting an idea of how to be managing credit month to month. We can do rental counseling. So we often work with clients that may be dealing with rental issues, may need help networking as far as who to get advice from legally, even in terms of learning a little bit about where to be getting affordable rental and how that sign-up process works. We do pre-purchase counseling, where we work with clients that sometimes they may be 2 years out of buying and just really wanting to talk about what programs they can take advantage of and how much they need to be saving, where their credit should be. Sometimes it's people that are actually in the home buying process and need somebody to talk to as far as comparing loan estimates, making sure that they trust their home buying team. And as I mentioned before, really making sure that you know about all the good programs out there that can be helping out with the down payment, such as the Illinois Housing Development Authority, Federal Home Loan Bank Chicago, even sometimes lenders that do kind of in-house down payment assistance. We go over all that so you know kind of what tools are out there for you to use. We do post-purchase counseling, which is just kind of basically talking to you about options like refinancing your mortgage, doing renovation loans, how to be kind of maintaining the property long-term and making sure that you feel confident with the financial investment you've made. And lastly here would be foreclosure intervention counseling. So this is usually where we help with really understanding what your options are with your loan servicer if you are in default, what you need to be kind of thinking of. We can't give legal advice, but we can at least kind of talk through the court timeline with you. We can talk about what usually the options are depending on kind of where you're at and how far behind you are. And in a lot of cases, we can even help homeowners find programs that may be able to help out as long as they're eligible, catch back up. So a lot of the time that's been through the Illinois Housing Development Authority. That's actually what we've been doing as of late with IDA through the HAF program. Round 1 started back in the spring, and we're actually going to be starting round 2 on 1st of November, I believe. So yeah, if you know anybody that may need that, we're here to help with pretty much everything on this list. And last thing before I hand it over to Katie is just going to say this presentation does not constitute legal advice or a legal opinion on any matter discussed. This presentation is for educational purposes only. And with that, Katie, I'll let you take it away.
Okay. First of all, thank you for the Great Lakes Credit Union for inviting me to speak with you all today about renters' rights. We definitely like to get information out to our communities. And just a little background about Prairie State Legal Services. We are a free legal aid service that services the top part of Illinois, minus Cook County. We have 11 offices in the top part of Illinois. We serve individuals over 60 years of age, persons with disabilities, veterans, and individuals with low income. What we can help on are civil legal matters outside of fee pursue situations. And as John said, this presentation is more for information. It does not constitute legal advice. Every legal issue, even if it might fall in the same category, is different. It's very fact specific. So if you do have questions beyond this presentation, please seek out legal assistance. So to begin the presentation, understanding your lease. The lease is the main document that sets the boundaries for the relationship between the tenant and the landlord. At the minimum, it guarantees your right of housing for a specific time and at a specific fixed cost. It lays out all your responsibilities and obligations during the term of your lease. And it can be best practice that it would be in writing, but oral leases are completely legal and valid. If you do have a written lease, we strongly encourage you to read through it and ask questions. The minute you sign your lease, you've essentially said that I have read through this and I do agree to all the provisions. And also the best practice would be that if it is in writing, that you keep a copy of your lease. Next slide, please. As I said, the lease does provide you a list of your obligations during your tenancy. I would preface this with Illinois eviction law, it heavily favors the landlord. So the first obligation that you have in your lease is to pay your rent on time. There's essentially no defense to non-payment of rent. So that's the first piece of information we always provide our clients. Even during the times of the pandemic, or if you have children or a disability, or there is a threat to homeless, it will not matter. There is no defense to non-payment of rent. Even if you have conditions issues, you need to pay your rent. The lease will also lay out your obligations in regards to repairs and upkeep of your unit. So make sure you read through that, make sure you are complying with that. Main obligations in your lease are probably going to involve making sure that you timely notify your landlord of any need for repairs or conditions. It's going to probably require you to keep your unit clean and safe, make sure that walkways are clear. And it'll probably advise you that only specific people can live in the unit, and that apologies. It will also provide usually how notices are going to be given, how rent is going to be received. It will also provide information on renewing the lease. It doesn't have to provide that. Very specifically, if it's a private lease, a tenant doesn't have a right to have that lease renewed. The landlord absolutely can choose to not renew it. And if you stay over the term of your lease, you can put yourself in jeopardy of eviction. Next slide, please. The flip side of this is that the lease lays out the responsibilities of the landlord. More specifically, since the landlord has created the lease, they wrote the lease, they provided the lease, if there are any disagreements, the lease or it's silent on provisions or it's poorly written, the lease will be construed against the landlord. So if the lease leaves out anything or has any ambiguous language, that's the landlord's fault. The landlord cannot oblige a tenant to do anything outside of the lease. Again, it's an agreement between both parties, so you want to make sure that you know what it is and you have the right to enforce it against your landlord. The lease also is going to create your right or the tenant's right to be evicted by the landlord. I know that sounds like a weird phrasing, but since it has this agreement for the tenancy, the creation of the tenancy automatically requires or provides the right to be evicted. They can't just remove you from the unit. They do have to go through the legal process. The landlord has the right or has the obligation to return your security deposit to you after you move out, minus normal wear and tear. Always look to the lease for the timing on that. If it's over, if the lease does not provide any provision about security deposit return, if it's 5 units or more, it's 45 days. If it's less than that, case law has deemed reasonable time for return of a security deposit, and that's usually interpreted as 30 days. Next slide, please. So, and this, the lease is going to provide, well, usually will provide some sort of provision about your landlord's right to access. This has definitely been an issue throughout the pandemic. And also with this current renters market. Again, always look at the lease. The landlord or their agents do have a reasonable right to access, whether they're inspecting the unit or making repairs. The reasonable right to access is going to be related to the reason why they need to be in the unit. If it's an emergency reason, an emergency repair like a leak or a fire, it is reasonable for them to probably come immediately as opposed to requiring written notice 24 to 48 hours ahead of time. In this day and age, a lot of individuals use text or email to provide that notice because that's how they're communicating with the landlord. That is absolutely a valid way to provide notice of access or notice that they are going to come review the unit. Next slide, please. So the state of Illinois actually provides a lot of protections for individuals in protected classes. The federal law is the Fair Housing Act, obviously applicable to the state of Illinois. It provides protections in housing related to discrimination, whether you're disabled, based on your race, your sex, your color, your national origin, your religion, or familial status. Next slide, please. In addition to the Fair Housing Act, Illinois has their Human Rights Act, which covers additional protected classes, such as age, marital status, your military status, if you've received an order of protection due to domestic violence or stalking, pregnancy, your sexual orientation, and as of January 1st, 2020, it also includes your arrest record. And I want to be very specific. It protects your arrest record, not a conviction record. Those are two separate things. And beginning January 1st of 2023, another protected class in the Illinois Human Rights Act will be your source of income. So a landlord cannot discriminate against you if you have, for instance, a Section 8 voucher. That would be helpful if it was enacted now, but it will be effective January 1st of 2023. So next slide. Let's talk about what some of these discriminatory actions would be. Rarely are they overt or intentional acts. They can show themselves, they can exhibit these acts as like maybe a landlord is maybe providing a false statement about the availability of a unit to an individual in a protected class. They might refuse to sell or rent to negotiate a lease with an individual based on discrimination. They might have discriminatory terms or conditions. For example, maybe they're renting the same unit or a similar unit in a building to different individuals, but for different amounts of money. Maybe they're only charging like $950 to a white person, but they're charging $1,000 for a similar unit to a black person. There's also covert treatment. Other intentional acts have also included sexual harassment. This could be requiring sexual favors to get access to a unit or to lower rent, or maybe a landlord's just creating a hostile living environment. Any type of discriminatory act or sexual harassment by any of the landlord's agents applies. So from the owner to the maintenance man. If these behaviors, discriminatory behaviors, are being exhibited, they are protected under the Fair Housing Act and the Illinois Human Rights Act. Where we most see any type of violation usually deals with disability. Maybe making units accessible to individuals with disability, or maybe making administrative changes to a housing program so it's accessible to an individual with a disability. These are very specific and complicated cases. I would strongly encourage any individual who is experiencing, who believes they're experiencing discrimination or would require assistance to access housing due to disability, please contact an attorney. Next slide, please. So the reasons for eviction essentially fall into two categories. It's either going to be money-based or lease violation. So always look to the lease to determine what the landlord can sue for in regards to financial amounts. Case law says you can only sue for rent. However, the lease might include late fees or repairs, or maybe attorney's fees that can be listed as unpaid rent, and they can sue for that. So always look at your lease, what is eligible to be sued for back rent. When you're looking at for cause reasons, always look at what were your obligations to the lease, and did you meet that obligation? If you didn't, the landlord can sue for failure to meet that obligation or violating that obligation. I want to specifically point out under for cause holdover. That is something we definitely saw a lot in the pandemic, where individuals stay past the end date of their lease. As I said previously, private leases don't have a right to renew under the law. Always look to your lease. What are the renewal provisions? If there are none, you are expected to be out of the property at the end date of your lease. If you are not out of the property, the landlord can sue the tenant for eviction, and unfortunately there's no defense to holdover. I would also point out that even for alleged violations, the landlord has the burden of proof whenever they bring those to court. They have to show to a judge or jury that by the preponderance of the evidence, or more simply put, more likely than not, the tenant violated the lease. They must provide firsthand, clear and convincing evidence. So I would strongly encourage anybody who does receive a notice for a lease violation to contact an attorney, because the landlord has a pretty heavy burden, and we would advise you to have the matter reviewed to potentially argue it in court. Next slide, please. Okay, so to begin any type of eviction procedure, whether it's an oral lease or a written lease, the landlord has to provide a written notice. And this is something where, unless specified in the lease, text and email do not count as notice. Our courts are still upholding that there has to be this physical piece of paper that is given to the tenant for whatever reason they are going forward with, whether it's a 5-day notice for unpaid rent, or a 10 to 14-day notice for lease violation, or if you're in a month-to-month lease, it would either be 30 or 60-day notice. So it does have to start with this with an actual physical piece of paper. Look to the lease, how the notice can be served. Usually leases require it has to be served in person or by mail. There's very persuasive case law that I know a lot of jurisdictions follow through, that just posting a notice is not good enough. Or if a landlord is going to post notice, they also have to provide notice in a second manner, either, again, usually by mail or personal service. And I can't stress this enough, actual notice is not good enough. So just because the landlord might verbally tell you or tell you by phone or text or whatnot, that is not good enough. Next slide, please. So every jurisdiction in the state of Illinois, and by jurisdiction, I mean county, is different as far as a eviction timeline. So I can't give a strict day timeline for evictions. I practice in Lake County. I could give you that timeline. I'm not going to, because I don't want to, I don't want individuals to come away from this with that timeline, because there are some jurisdictions where it does not apply. At the very minimum, I can give you the steps that are required in the timeline. The eviction timeline, again, starts with a potential action or inaction by the tenant. So maybe it's a non-payment of rent or some alleged lease violation. Then they require notice from the landlord that the landlord does want to seek eviction. After the time in the notice expires, the landlord has to file a complaint with the court, and that complaint needs to be physically served on the tenant or anybody over the age of 13 in the household. That summons is going to give you the date of your return of service or your first court date. And that first court date, it determines whether you were served properly and what the next steps would be. I can speak with some confidence that a lot of jurisdictions right now for rent-only cases are setting those to mediation, and also encouraging them or even just pushing them to complete rental assistance applications. So to avoid any type of trial, if parties can't work it out, the court can set for trial. And worst case scenario, if the court finds in favor of the landlord, only the sheriff can physically remove the tenant. Even if the landlord has a court order, they cannot do anything to illegally remove the tenant. They can't change the locks. They can't tamper with the utilities. Only the sheriff can enforce the eviction. Just want to make sure I hit all the highlights on that. All right, next slide, please. So once an eviction is filed, there are many types of outcomes. And a lot of these are pretty valid right now because we still have mediation available across the state, and there's still very much rental assistance available. In fact, I'm going to talk about it in a couple more slides. Court-based rental assistance will be going through into middle of next year. So a lot of these outcomes are very valid. If a tenant is personally served and they don't show up for their court date, the landlord will receive what's called a default eviction, which means since the tenant was a no-show, the court automatically orders the eviction in the landlord's favor. The next type of outcome would be dismissal, and this is maybe between the time of service on the tenant to the first court date. maybe the parties were able to work something out. Maybe rent was paid, or there was an agreed out-of-court settlement, and the parties can dismiss the case. They can do it with or without prejudice. If it's without prejudice, the landlord does have the right to refile. But if there is a dismissal that day, it ends the court matter. Parties can seek a settlement after the first court date, and this has been occurring more frequently, again, because of the mediation programs and the rental assistance available. Agreements are very specific and tailored to the individual parties. They might include an agreement where it's pay and stay. We got the rental assistance, you can stay, and we'll dismiss the eviction. Or maybe there's some sort of contingency agreement where maybe they're choosing not to go forward on the rent amount, but there's an agreement that they will move out by a certain date. And if they're out by a certain date, we'll vacate the eviction. There's all different types of agreements, all different types of outcomes. So it's very specific to the parties and their cases, but that is one option that can also end the court matter. And then the final option, and it's just not used as often, is trial. Parties absolutely have the right to a trial. The landlord or the tenant can absolutely seek trial, and a judge or a jury can make a decision after hearing both sides' testimony, both sides' evidence, and the judge would issue some sort of decision based on the evidence presented by both parties. Next slide, please. So as I talked about this a little bit before, about only the sheriff can enforce the eviction order. Definitely through the pandemic, there are a lot of attempts of illegal lockouts. Unfortunately, landlords wanted their property back. Individuals were holding over. There was the eviction moratorium, and perhaps relationships became strained. And but tenants have the protection from illegal lockouts. So it begins with, as I said earlier, that if you're in a lease, written or oral, you have the right to be evicted. And it ends with, even if you go through trial and you do have an eviction entered against you, only the sheriff can enforce that order, not your landlord. So as you see here, there are a bunch of ways and methods that we have seen landlords try to remove tenants individually. And it can be something as physical as changing the locks to your door, to removing your belongings, shutting off utilities, providing or making physical threats. If any of this occurs, you need to contact the police immediately. I know our representative area, the top part of Illinois minus Cook County, our offices did a lot of advocacy with city police departments during the pandemic to explain that only the sheriff can enforce the court order. I think we've been fairly successful. So that's why we would encourage individuals to contact the police if this occurs. And then we would also advise them to contact an attorney. Next slide, please. So another law that was created during the pandemic that is no longer in existence was automatic sealing. Sealing is definitely a very important tool in allowing a tenant to rent another apartment in the future. What does it mean? basically hides the eviction. Most jurisdictions, I would say probably all of them, if you go on their clerk's website, you can look up a name and you can find filings against an individual. With sealing, or the term that they also use in court, impounding, even if an eviction was filed, even if an eviction order was entered, sealing hid that case entirely. So you couldn't pull it up online. It won't show up on your credit record. So for a period of time, cases were automatically sealed in the state of Illinois. That ended March 30th of this year. It was basically cases between March 20th of 2020 till March 30th of 2022, cases were automatically sealed. That is no longer the case. It's a little bit harder. There's still an option to request it in court, but it's just a little bit more difficult. And it usually requires that the initial case had no basis in fact or law. So maybe the landlord's saying you owe rent. You would actually have to show that at no time did you owe rent, you were paid up, this was filed improperly, or if they filed for cause, that their allegation was completely unfounded. What also helps, I found in our jurisdiction, if both parties agree to the sealing. But this is how these factors are interpreted and enforced by judges is different from jurisdiction to jurisdiction. But sealing is definitely something that is available, and it's something that when I was talking about maybe work out an agreement, maybe this could be added to an agreement. Like maybe I'll move out, but you agree to seal the case. So it definitely is a helpful negotiation tool, and it can definitely help individuals find new housing. Next slide, please. So as I said previously, there is court-based rental assistance available. Information about that rental assistance can be found at the IDA website. The court-based rental assistance does require that you have an active court case. So there has been eviction filed, you've been served. You do have to show that there is a pandemic-related hardship, but this is a very broad term. That could be something where you actually had COVID and you couldn't work, to my kid's daycare shut down and I couldn't get to work, so I lost income. There are many ways that you can exhibit a COVID-related hardship, not just if you had COVID and you didn't have income. The household must be behind in rent. The household must be below 80% AMI. I know when I say that, that's not terribly helpful. You can Google a chart online, but that 80% AMI is going to be different for different sizes of households. So I can't give you a firm number on that. The rental assistance can cover, or court-based rental assistance can cover up to 15 months of rent, 12 months in back rent, and 3 months of rent going forward. And what I found in my practice, is that it actually is processed and approved fairly quickly, and I would say more quickly than FARA and IDA applications previously. The other website I provided, there's also Illinois Housing and Help, which also provides some other local-based rental assistance, and it also has a search engine for rental housing. I understand that is a huge issue right now. And it does provide listings, and I think they're fairly credible listings. Always make sure that you're vetting out potential places that you're going to rent. And then the final website I provided was illinoislegalaid.org. This is a wonderful website that provides up-to-date, attorney-sourced legal information. They have a bunch of forms for pro se litigants. So if you wanted to file a motion to dismiss in your eviction, they have forms that can help you fill it out. And it's not just housing. They have information on family law, public benefits. I just really love this site because it is so frequently updated, and it is sourced by actual attorneys. So it's a very credible website. And that's all the information I have. So thank you.
Oh, well, that was absolutely phenomenal, Katie. We really appreciate all that wonderful information. Um, uh, One thing I would like to mention, and I was monitoring the chat and communicating with a colleague via text. So you might have said this, but so I'm sorry if I'm repeating. The IDA, a court-based rental assistance program, is for outside of Cook County. But my understanding is that the Cook County Rental Assistance Program, court-based, and let me back up, court-based rental assistance program is reopening. I don't know if it's opened yet, but my understanding is it's reopening. So basically, between the two programs, you have all the entire state of Illinois covered. Um, and it was really good to hear that this is going on until middle of next year. So the court-based rental assistance programs are for people who are already in court. So you have to have a summons to participate in that program. Okay, well, anyway, I have to say, really phenomenal information. Thank you so much, Katie, for participating and sharing your knowledge with us and our communities. Um, if you want to get a hold of the Housing Counseling Department at Great Lakes Credit Union, there's a variety of ways you can do that. You can go to the Great Lakes Credit Union website. That is the actual address that you can put into a browser, or you can simply go to the bank section in the menu and then look for education and housing counseling. They put us at the bottom of the list, but we are there. um, so anyway, the other option is to call us directly. We now have an admin person, and so it's easier to get through on that line and to reach somebody, somebody answering that phone. So that phone number is 224-252-2620. Or you can send us an email, and that's housing@glcu.org. Next slide, please. Oh, there's the contact information for Prairie State Legal. I want to reemphasize that they do assist people outside of Cook County. Um, the housing counselors at Great Lakes Credit Union do have other resources for those who are in Cook County, so you can contact us for those. But this is their web address. That's www.pslegal.org. And that's how you would put it in a browser there with all the other items listed. Or you can simply call by phone. That's 1-800-537-7057. Next slide, please. So we've come to the end of our presentation. I have to give Katie a pat on the back for doing a phenomenal job and presenting a lot of good information in a very efficient amount of time. But this is your opportunity to ask questions. If you could put your questions in the chat box, I am monitoring the chat box, and I will repeat those questions. And most likely Katie will be answering most of them, but if there's something that I could answer or John will answer, we will also take care of those. And while we're waiting for questions to be put in the chat, Katie, um, I have a couple of questions for you. So can you unmute yourself? There, great, excellent,
Yep.
thank you. Okay, so do you said there's a couple things I want to ask you about. Do other free legal entities advocate for tenants with the police like you do?
I can't speak for them.
Okay, okay,
Yeah.
okay. I just thought that was wonderful. I did have a client who had mafia-like encounters with people who associated with her landlord. It was a very scary situation for her and for me as her counselor. And so it's just that's a great thing that you do. So I really appreciate that. And my other question is, or let me just preface my question with this piece of information. So we as counselors uh, can help people file fair housing complaints. And I know that when you are filing a fair housing complaint, you don't actually have to have evidence of the discrimination. You just have to suspect that you're being discriminated against. But I was wondering if, Katie, that might be different for coming to see an attorney. And I was wondering if someone is going to come to see an attorney with a concern about fair housing discrimination, do you require that they have evidence of it or just simply suspect that they're being discriminated against?
Um, Both, but we would handle them differently because we do have a fair housing program at Prairie State, and we do have testers, meaning if we potentially, if somebody believed they were being discriminated against, we might send out testers to those properties. But if they went to file a specific complaint where they thought, I guess it would depend on the complaint, but for filing a fair housing complaint, or at least for us to be successful in it, evidence is going to be very helpful.
Yes, yes, yes. Oh, that's great that you have testers. I'm really impressed. Um, and that could potentially provide the evidence that is needed.
Yeah.
So, and see, I always think that um, seeing an attorney is a great thing anyway, because just having an attorney on your side can make all the difference in the world, even if they simply write a letter to your landlord or a potential landlord or something. But I don't want to speak for what you do. I just want to say I think having an attorney on your side is great. We do have questions in the chat, so I am going to review those. Okay. Let's see. I know that I'm going to just read the question as it's stated, and then we can unpack it.
Okay.
I know that you stated that the lease should state basically what the landlord is expecting of us, fees, etc. My landlord, which I've been with since 2019, knew I had a cat, but charged me no fee, and fees for pets are not listed in the lease. As of as of last year, they started charging me randomly middle of the lease for my dogs, and I now and I know no, oh, I'm sorry. I now, as of July, only have 2 dogs, and I am still consistently being charged. I've contacted them numerous times, not sure what route to go. I hope that was clear, Katie.
Yeah, I'm not gonna, this is one of those questions that's too specific, and I would encourage this individual to contact one of our local offices, or if they're not in our service area, to look up places on illinoislegalaid.org, because this is This is a very case specific question, so I apologize. I would start with the lease, but it needs to be answered by somebody who's reviewing your lease and specific facts of your case.
And that's the perfect answer, Katie. We appreciate that. Great. Okay. I have another question. Can a person be evicted even though they have applied and been approved for rental assistance? There's a great question.
So yes, yes, that's a good question. Short answer, yes, because the landlord is under no obligation to cooperate or accept it, unfortunately. The landlord does have the obligation to mitigate their own damages. I can only speak to our jurisdiction, where our judge is strongly encouraging landlords to go through rental assistance. But if they don't, he will grant them the eviction, but he's not going to give them a dime in the order. So the landlord has to, in our jurisdiction, the landlord would need to pick a lane. I'm either going to agree to cooperate with rental assistance and allow the person to stay, or I want my property back and I'm going to just have to waive any right for back rent.
Okay, great. I know, I want to add something to what you said. I know with IDAS, that's Illinois Housing Development Authority, this is the state's court-based rental assistance program. They are moving those applications through quickly. Rather than if you applied to the rental assistance program in the past and it took a long time, you know, maybe you were denied. If you feel like you have a legitimate reason to that you shouldn't have been denied, and you are now in court or you've been served a summons, you can apply for the court-based rental assistance program. This is IDA's program, and it is for outside of Cook County, but they are moving those applications through quickly. So in other words, there's an answer soon. The landlord is not going to have to wait for a long time. But I really appreciate your answer there as well, Katie. And if you have any other further questions, please put those into the chat. I am going to be adding also a feedback form in the chat, because feedback helps us to improve our webinars, and we're always looking to improve. So I will be adding that shortly. If you have any additional questions please write them into the chat now. We still have some time. And while we're waiting, John, if you have anything you would like to add or questions that you have, I know I came up with questions. I think we do. I'm sorry, go right ahead.
I guess just two things. One, I'll reiterate, like we're on public radio, to please fill out those intakes that we put up a link for at the beginning of this. It just helps us out a lot as far as just helping us have credit for the good work we do. Other thing I was just curious about, though, since we were kind of talking about not under any obligation to take, like, say, rental assistance. Katie, if there's evidence, though, that landlord did take a check, say, from like the state housing authority and is acting as if they didn't receive it, is that something where, like, Free Legal or Prairie State, would it be able to intervene and help out?
Yes, and we have dealt with cases like that, unfortunately. And anytime when there's money involved in a state entity, there's going to be a paper trail. So those are, I hate to use the word fun, but they're fun.
I mean, I would think it would not be very intelligent on landlord's part to do that, since, yeah, it's pretty obvious that there would be a paper trail.
Yeah.
We do have one more question in the chat. Is there a place that can help with deposit when a person has to move? So, and my understanding of this question, and if I'm not correct, is if you're looking for like help with first month's rent and security deposit, that's how I took that question. Kate, well, actually, I was going to turn it over to Katie, but I can comment on that. I know my office, as I said, in Country Club Hills, and I know that there is a Cook County Homeless Prevention Call Center. I have the phone number for it. And you can call that call center and tell them what you need help with, and they will try to hook you up with an agency that has funds and that can help you. So yes, there are places that can help you. I do actually have the phone numbers for the direct dial. In Chicago, you could just dial 311. I have the phone numbers not in front of me, but I do have the phone numbers for the Lake County call center and the suburban Cook County call center, the actual phone numbers. And I actually have a direct dial for the 311 as well. If you're, for some reason, you're calling on behalf of somebody, you're outside of Chicago, but you're calling on behalf of somebody, or your cell phone doesn't have the right area code, and you need those numbers. But so yes, there are places. You might want to look up Continuum of Care or Homeless Prevention Call Center phone numbers. See if that works for you as well. You can always send an email through to our email address, and ask if you have a question like that. You can send an email through to our email address. And Katie, did you want to add anything, or John, did you want to add anything to what I just said?
I have one other question if there aren't any more in the chat, and then I'll be finished.
I would just add, sorry. Township assistance, and that's going to be specific to your county, but but I would try township as well as all the suggestions Janine provided.
Yes, and the township offices are spread out. There's none in Chicago. There isn't one in Evanston, but they are spread out. At least for Northeast Illinois, they're spread out in all the suburban areas. As far as I know, just Chicago no longer has those township offices, and Evanston doesn't have one. But I can tell you that the one that is my township office for the Country Club Hills area, it's the Bremen Township office. They do have a general assistance office, and I believe they have funds. So, and I don't know what all they cover exactly. You'd have to call them, but that's a great idea. Thank you, Katie. And I do have one more question in the chat, if we can squeeze it in here before 12. I live in a multi-unit building, but the landlord has it that the lease, I should keep up landscaping, but I'm disabled. What can I do? And I'm going to turn that over to you, Katie.
It sounds like you would be eligible to make a reasonable accommodation. I would, though, strongly encourage you to contact an attorney to review the lease and discuss the specifics. Again, if you're not in Prairie State's jurisdiction, do go to illinoislegalaid.org. Especially if you're in Cook County, you would probably have several options of where to contact. But you should absolutely seek legal assistance for that issue.
Great. Okay. Wow. If you have any other questions, pop them in the chat quickly. It is 12 noon. And I'm sure all of you have a weekend, the rest of your weekend that you want to get started. So once again, Katie, This was phenomenal. I really appreciate this information, and I know all of our participants appreciate it as well. And I want to thank you for joining us again and taking time out of your busy schedule to share your knowledge with us. We really appreciate it. And I'll turn it back to John now.
No, I just got nothing else to say, but same thing, Janine. Thank you so much, Katie. We really, really appreciate just all the help on this and good communication to the community out there. And thank you everybody else for just joining us today on a Saturday and coming out here and hopefully getting some helpful tips. So yeah, whether it's Prairie State or GLCU, we're definitely around. We all want to help. So just give us a ring if any help is needed. And otherwise, have a good weekend, everyone.
Thank you.
Thank you for joining us, everyone.
Have a good one.
Have a great weekend.